remove this message, this recording thing.
No, at least what I did, because it used to come in after the hearing had actually started and go. At least now it's better because at least it comes before the actual hearing starts.
Thank you.
At least what I did, because it used to come. Are council coming through?
Yes.
We are here, Justice.
Oh. Just Ron, please.
Acting Chief Justice, I do believe all the parties representatives are online. Can we ask?
No, please do not promote me. You just promoted me to Acting Chief Justice.
Oh, I apologize. Presiding Justice, can I ask the registrar clerk to recording?
Yes, please. Thanks, Mrs. Theron.
Good morning. I am the registrar clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of Shiva Uranium Pty Limited in Business Rescue and another, and Mahomed, Mahier, Tayob, and others for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the court, I appear for the applicants together with my learned friend, Mr. Wickens.
Thank you, Mr. Simon.
Justice, I appear for the first and second respondents, Mrs. Tayob and January.
Thank you, Mr. Lowe. Yes, Mr. Simon.
Thank you, Justices. I intend, due to the kind offer made to me, to spend 10 minutes just giving a brief structural outline of the case, and then I'll be happy to field any questions which the learned justices have. By way of brief outline, if I may say this, 2018 is a momentous year in the life of the Shiva company. In February 2018, it was placed in voluntary business rescue, and the company appointed, as Section 129 of the Companies Act envisages, 2 business rescue practitioners. Within a month, there was an application by the majority voting creditor to remove those business practitioners in terms of Section 131B of the Act. And the result of that was the appointment of 2 further business rescue practitioners. Thereafter, almost immediately after their appointment, the company passed a resolution appointing 2 alternative business rescue practitioners, resulting in 2 rival contesters for their position of business rescue practitioner. Then there evolved a series of litigation, all complete before the end of the year, implicating the company's tribunal, then the High Court, and ultimately, with the leave of the Supreme Court of Appeal, a decision a bit later on by the Supreme Court of Appeal, and thereafter this application to you for leave to appeal and for relief on the merits by the applicants. And what we have here is a fundamental contest between the 2 rival sets of business practitioners. But the question before you is specifically posed as being one as to whether the resolution appointing the 2 alternative business rescue practitioners at the instance of the board of directors of the company is valid. And you see that at volume 1, page 130, where, if I may take you there, where the problem is posed. At volume 1, page 130, sorry, I beg your pardon. That is, in fact, volume 2 at page 130. This is the notice of application for leave to appeal, where the question is posed by us in the notice of motion, and the relief sought is whether is a declarative that the second and third respondents were not validly appointed by the first applicant's board of directors as the business rescue practitioners of the first applicant. So the question is posed specifically with respect to the validity of the rival appointment at the instance of the board. And you'll see also at page 158, which is part of the judgment of the SCA, that what it found as part of its order at 158 is that the appeal was upheld and the order of the court a quo was replaced with the following order. It is declared that the applicants were validly appointed as business rescue practitioners of the first respondent. Again, the focus is on the validity of that appointment. And if I may draw to your attention paragraph 12 of the SCA judgment, which you'll find at paragraph 153, where the SCA noted that before us, the respondents raised a new argument. They submitted that only the IDC, that's the majority voting creditor, had the power to appoint a substitute for Mr. Murray to the exclusion of the board. The argument was based on the fact that the IDC had recommended the appointment of Mr. Murray. As I've said, however, the central question is whether the applicants are correct that only the board had their power to appoint them as practitioners for Shiva. So properly framed, the debate before you centers around the question of whether the company resolution was valid. Now, the complaint raised by our opponents is in this leave to appeal, we seek to advance a new conceptual ground and a new factual ground for our contention that the company's resolution was not valid for the appointment of the board of directors. The first part of it, the conceptual ground, being that we had previously raised the argument that it was necessary for the business rescue practitioners to approve of the resolution by the company before it came into effect. But now the ground, they say, has conceptually shifted in the sense that we're saying that, in fact, the proper person to have made the appointment was the IDC, or to have recommended or nominated, and that's a debate which we'll have to have. And they say that's impermissible because it's a new ground and it's a new conceptual ground. The answer to that, respectfully, is that in an appeal, the question is not raised as to the reasoning of the court from which the appeal emerges, but rather the order. So there's no problem with raising a new conceptual ground. In any event, it was raised before the SCA, as you can see, and it is the counterpoint to the argument in relation to whether the company was the correct appointing authority in order to make the substitute appointment. So, and as far as the facts go, the facts, the second complaint they have that it is a new ground is a factual one, and the elaboration that comes in this application is that the IDC's role was behind the resolution passed by the two business rescue practitioners on whose behalf I really speak. And in regard to that resolution, what you find on the facts is that that in fact represents the will of the IDC as was ascertained. Whether and to what extent you entertain that application as raising facts which now emerge is a matter which we can debate. But the central question is not that. The central question, as I've posed it, as recognized by the SCA, is the question whether the company resolution was valid. That takes us to the second part of the argument. The second part of the argument is this. Now, our contention to you is that on a proper construction of sections 129, 130, 131, and 139 of the Companies Act, there is a certain symmetry and a certain consistency and a certain purpose of logic. And the logic would be fundamentally defeated if you were to recognize that the initial initiating authority for the appointment of the business rescue practitioners was the company, and that would endure beyond the intervention by way of a novus actus of the court, which resulted in the appointment of 2 other business rescue practitioners, and thereafter the resignation of one and the way to substitute it. And if you went backwards in time to when the original resolution was passed, you would be respectfully appointing or recognizing the authority of the wrong company or the wrong institution for the appointment of the 2 new business rescue practitioners. And the reason why we say that is that the fulcrum of power shifts in a business rescue from the board of directors to the creditors in order to try and achieve the implementation and acceptance of a business rescue plan. The role of the directors, although still there, is auxiliary, it's of less importance, and the business rescue practitioner is of far more importance. And the symmetry is this. When the company passes the resolution putting the company into voluntary supervision, it is the only initiating authority which is able at that point to make the appointment of the business rescue practitioners. And it is appropriate that it then does so because it has voluntarily accepted that the company is in financial difficulty and that supervision is appropriate, and it should then be entrusted with the decision as to who the business rescue practitioners are.
Mr. Simon, the 10 minutes is up. Colleagues may now put questions to you. May I just ask this one? If you were to get the declarator in 2.2 of your notice of motion, would we be left with any business rescue practitioner? If so, who and on what basis?
Yes, Justice. So what would then be left is there would be, and that doesn't seem to be contested other than in passing. Mr. Maniela's appointment is not specifically contested other than in the argument that
but all by himself, he will be as good as not there because he's a junior practitioner, and it's agreed that as a matter of law and fact here, we must have a senior practitioner. So I think let's look beyond him to answer.
So I think the answer to that question is this: that the what will happen is would be dependent on the outcome of your judgment, because in your judgment, you, in order to make the declarator as to the invalidity of the appointment at the instance of the company, you would have dealt with the argument as to whether the court order of Mr. Justice Ranchod was valid and whether anything could have flown from it. And you would have made the decision as to who is the initiating appointee. If from your order and the directions that you give in your judgment, it is apparent how an appointment must be made, it can then be pursued. But as far as Mr. Maniela is concerned, he is a business rescue practitioner, and there is no PAJA application for his removal. And in the interim, there is no reason why he cannot function. It may be that he should or should not have been appointed in the first place, but be that as it may, he is still there and he has the residual right to represent the company's interest. And your guidance that will come from the order will determine whether what happened as a fact is acceptable in terms of business rescue, and that may lead to other processes. But what you do have as a fact at the moment is that there is respectfully the Mr. Justice Ranchod's court order, pursuant to which Mr. Maniela was appointed and Mr. Murray was appointed. If you were to find that the company resolution couldn't alter that, then what you do have is you have the appointment of Mr. Monyela and you have the appointment of Mr. Damons if your order is to the effect that the IDC made that nomination stroke recommendation stroke appointment. And that should resolve the matter automatically by your reasoning. If it's deficient, then the reasoning will give the path forward for a proper appointment.
If you all the way to the appointment of Mr. Damons, then you can't avoid the factual issue. And that raises a totally different can of worms altogether. So it's either that you are left with Mr. Monyela, and in my view as presently advised, I just cannot see as a matter of law how he can act all on his own when the law in so many words says for this size company, you must have a senior practitioner. So as a matter of law, I just do not. And then if you say we have Mr. Damons as a result of the appointment by Mr. Murray and Mr. Monyela, then the factual conundrum stares us right in the face.
I mean, that is so, Justice. So in order, if the question before you was one as to the validity of that appointment, then you need to deal with it respectfully on a conceptual level and on a factual level. But that's not the question that is before you. The question before you...
No, I understand that. I understood your introduction of what the issue is perfectly well, which is why when I raised the issue that I raised, I zoomed in on exactly what you identified, which is in particular paragraph 2.2 of your notice of motion. But now I just wanted to be forward-looking to understand where all of this would lead. Where are we? Because we have a company that wants business rescue, and I would imagine it wants it done yesterday. So where are we? Do we or do we not have? It's in that context that I was asking the question. It's purely in that context.
Well, our submission would be along the lines of our written submissions. It would be that the matter will play itself out in a way which would indicate the validity of the appointment of both Mr. Monyela and Mr. Davids. So you are right respectfully to say that implicates that factual question, but that factual question then must be addressed with the materials that you have in front of you.
Let's do that. Let's do that. We have resolution by Mr. Murray and Mr. Monyela. We have an averment by Mr. Tayob. I hope I'm pronouncing the name correctly. In his founding affidavit in the High Court, I do not know whether it's paragraph 6.12, but it's 6 point something, where Mr. Tayob says, Mr. Monyela, in his founding affidavit before the tribunal, said that he and Mr. Murray were acting for and on behalf of the company. I'm paraphrasing. And that was not denied in the answering affidavit deposed by Mr. Monyela himself. That was not denied. And in fact, it could not have been denied, not in the face of the resolution that says in so many words that Mr. Monyela and Mr. Murray were acting for and on behalf of the company in resolving to appoint Mr. Damons. Is there any cogent basis on which the applicants can now ever suggest factually that the appointment was at the behest of the IDC?
Justice, the answer to that question is given in the replying affidavit, and either in the replying affidavit in this application. And you will either accept it on its terms, or you will regard it as insufficient or inadequately explored, or whatever line that you would wish to adopt to it. So if I may
Please
refer
remind
you
me,
to...
please, I'm sorry to interrupt you. Please remind me, did we grant leave for the filing of a replying affidavit? I'm not saying we did not, but I don't remember.
I don't think there was
the
any
process here is that
specific...
the replying affidavits are only filed with the leave of the court. It's only the founding affidavit and an answering affidavit, reply only with leave. Did we grant leave? Do you remember?
I don't think there was any specific order about leave to reply. I don't think there was an application for it, and I don't think any specific order was made for it.
Can we take it into account then if it was filed without leave?
Well, I think that is a matter for your discretion at this juncture. But the point that is made is perhaps not a novel or a revolutionary one, because it is in line with what has been suggested before. So in the founding affidavit, maybe it's necessary just to look a little bit at that sequence and see exactly what that sequence reveals, because it finds its way in the all the way through. So in the founding affidavit at paragraph 22, which you'll find at page 139. So at page 139, you have this paragraph 22, which was identified for criticism by Mr. Tayob. And what this says is that Mr. Murray and I held the view that because Mr. Murray, had been recommended and nominated by the IDC was both entitled and obliged to appoint his replacement. When we resolved to appoint Mr. Damons, we were simply giving effect to their right in terms of section 139.3 in this regard. We passed the resolution based on their nomination of Mr. Damons. They continue to support his appointment. To demonstrate their support, they filed an affidavit in the application brought by the respondents confirming their support for the nomination and appointment of Damons. I submit that this is in substance compliance with 139.3 and that he is a rescue practitioner appointed by a creditor as envisaged in 139.3. So the submission which I would make to you, just even on the basis of the founding affidavit, is that the resolution itself is of limited import. That resolution itself is merely giving effect to the will of the person, if you find that we are correct in our analysis of the sections, that was entitled to make the substitute appointment, which was the IDC. So the fact that the resolution says it's on behalf of the company is neither here nor there. The substance of this is at whose instance, who is the appointing authority within the company to make it. It's less the question of that resolution itself, because I'm not going to contend to you that the business rescue practitioners have the power by their resolution to appoint a substitute. I'm saying to you that of the possibilities that exist, there is the company, which is the argument of our opponents, and there is, as from our perspective, the correct initiating authority or appointing authority here is going to be the IDC. And you know on these facts that the allegation, even in the founding affidavit, is it was at their instance and with their support. And it develops all the way through, because if you were to have regard, and the conundrum which you raise, the issue which you raise, is specifically addressed in the reply. You might decide that it's not appropriate and you won't have a look at it. But for what it's worth, I'm not certain that it takes it very much further. It elaborates on it and may perhaps be of assistance to you. And you'll find it in the replying affidavit in a series of paragraphs which begin at paragraph 10 at page 308. And if you look at paragraph 10 at page 308, you see that the facts underlying, this is what he says, are a matter of record. The applicant's primary position is that Murray and he were giving effect to the IDC's choice of Mr. Damon's. It is not correct that there's no truth in this or that the resolution and filing are inconsistent with it. So they do purport, and he explains why they purport that it to be the company's resolution. When Murray decided to resign, and this is new fact, I'm making no bones about it, this has not been said before, and you'll consider the prejudice, if any, to the other side when you deal with this. He says, when Mr. Murray decided to resign in paragraph 11, I contacted Mr. Malloy, the head of legal at IDC, to inform him of the impending resignation. I explained that I was a junior practitioner and it was necessary that a senior practitioner be appointed to replace him. We discussed the possible replacements and Mr. Malloy was happy with Mr. Damon's. With that knowledge, I informed Mr. Murray that the IDC wanted Mr. Damon's to replace him. Then Mr. Murray prepared the resolution in the form which it appears, and he and I adopted it. I was happy with its form as we believed that it correctly and appropriately reflected what we in the IDC intended, and that the only way to give effect to the IDC's wish was that Mr. Damon's be appointed was through a resolution adopted by the company represented by Mr. Murray and me. And then in paragraph 13, he says, when we completed the SIP-C filing, we completed the form which only gives two alternatives. One is the company.
Mr. Simon, so as not to detain you too much on the facts, maybe just refer us, don't read, and then proceed to go back to your submissions, because I'm sure my colleagues will want to engage you on the law.
Thank you for that guidance, Justice. I'll honor it. And so they say that they selected the option of the company before they believed it was the way to do it. So I've no further submissions on that. But so my central submission in response to your question is that it doesn't really matter whether they said it was the company or whether they could or should have. The substance of the problem before you is who is the appointing authority. And our submission to you, based on a construction of the various sections of the Act, which I can elaborate on if anyone would like me to, is that the IDC is key. It's not the business rescue practitioners, not the company.
Mr. Simon, if my brother presiding is, yes, thank you. Just on that point, and also on your submission about the change intact in the applicant's case, and that you say there is in fact none. Isn't it so that in the High Court, the applicant's case was that the company could only appoint a replacement practitioner with the consent of the incumbent practitioner?
Yes.
So there was mentioned, it was referred to as the veto power of the practitioner. That was the applicant's case in the High Court.
Yes.
And that changed slightly in the SCA and now before us. Why should the applicant be allowed to change tact?
So, Justice, if I can answer it this way, my learned friend referred in his heads to authorities. And the authorities provide that, as we all know, that in motion proceedings, the affidavits stand as the evidence and the pleadings, and that there isn't a warrant ordinarily for going outside of them. However, even in those cases, there's recognition that arguments of law are permissible if they arise from what is already before the court, and provided that there's no prejudice. And ordinarily that comes mero moto from the courts. But there is no reason why, if a set of facts allows itself to be positioned in a different legal argument, that should be excluded. Changes of tact in regard to legal argument are not significant and shouldn't be excluded. Now, here they are, as I had submitted to in my opening address, there are two elements to this argument. The one is the conceptual element, and the one is the factual element. The conceptual element is the counterpoint to the legal argument that the company is entitled to make the appointment. it's inevitable that you have to respectfully traverse the issue of whether Section 139(3) encompasses an appointment which is made pursuant to Section 130 sub 6, where the court makes the appointment, assuming that court order is valid, which is a debate which we might have to have. But with regard to that, there is no, it's inevitable that as a matter of law, in considering the primary question of whether the company can validly pass a resolution, that you have to look at the role of the majority supporting creditor in the context of Section 130. And even the SCA judgment recognizes.
I'm sorry to interrupt you. I'm sorry to interrupt you. The basis of the judgment in the High Court was that the practitioners did have the veto power.
Yes.
In the Supreme Court of Appeal, the basis there was the rejection of that argument.
Yes.
So why in this court should a new argument now be considered? This is the apex court. This matter has already been to 2 other courts. Why should a different argument be considered for the first time in this court?
On the conceptual argument, it is the counterpoint to whatever exists. Because if you're looking at the validity of the company resolution appointing 2 substitute practitioners, and if you're looking at the SCA's own reasoning about how to interpret Section 139 sub 3, it's inevitable that you have to take cognizance of what appointment we're talking about and what replacement is necessary, which means you have to look at Section 131B and Section 136 in conjunction with Section 139 sub 3. So there's nothing new in that. That's purely a legal argument about the interpretation of the relevant provisions. It may be, and it may be that it was raised for the first time in the SCA, that is so. Until then, there had been a different legal argument raised. But the factual component, I mean, I take your ladyship's point, the factual component is a new one in the sense that what you're seeing unfold before you now are the facts relating to what happened pursuant to the IDC's wish. But you, as I have said, you respectfully don't have to decide that point in this appeal. The question on this appeal is whether the resolution was validly passed to appoint 2 rival business rescue practitioners. That question is before you. It was before the SCA. It was always inherent and doesn't raise anything new or which should be prejudicial. The factual element of it is a different matter. And I'm saying to you that you don't respectfully have to go into the factual matter at all, because it's not the question posed before this court. It's not the subject matter of this appeal. It may, as Justice Madlanga pointed out, it may mean that there's some uncertainty in relation to who is the proper appointment. But my answer to that is it will be resolved by the way the court decides the first conceptual question. Either there was a proper appointment or there wasn't, but it's not something respectfully that you have to understand. So my submission in brief is that there's nothing new or revolutionary or prejudicial or of any concern in raising the argument that the proper appointing authorities, the IDC, to rebut the argument that it is the company. It's always there and it's always inherently been there.
Mr. Simon, are the applicants here then to protect the interest of the IDC?
The applicants are here because there is a dispute between the parties before the court as to who is the correctly appointed business rescue practitioner. And the act is clinical. Either the act says that it is the one set of appointees who have a proper appointment or the other. And
Let me rephrase my question, Mr. Simon. Are the applicants here in order to protect the right of the IDC to appoint replacement practitioners?
The applicants are here in a number of different capacities and for a number of different purposes.
Is one of them to protect the interests of the creditors, the IDC?
Yes, the effect of the order would be that the IDC's interests are protected. There's no doubt about that.
Now my question is, the creditors remain in a position to apply to have a replacement practitioner removed in terms of section 130. That option is open to the IDC. Why cannot it proceed in terms of that section, in terms of instead of coming to this court?
Justice, in theory, that's a possibility, but it's not the question. The question is whether this appointment is valid. So to say that we would have a remedy if you recognize the IDC would have a remedy if you recognize the validity of the company's appointment is respectfully not to address the real question. The real question is the validity of the company's.
That's my question, Mr. Simon. Why shouldn't the IDC go the route of section 130 to protect whatever interest it may have in the appointment of a substitute practitioner instead of coming to this court?
There would be no reason why it couldn't if this appointment via resolution was valid, because the tail end of section 139.3 provides for an appointment, provides for a subsequent application under section 130B if you're dissatisfied with the company's appointment. But that begs the question, because the argument here is the company's appointment was invalid in the first place. It's an ameliorative, can I put it this way? It would be a remedy available to the IDC if this appointment is valid, but the validity of this appointment is the question before this court.
Justice Toronto, you
may proceed, Justice Ranchod.
Mr. Simon, two matters. In regard to the evidence of the IDC's involvement, there's been a debate as to whether you can have regard to your replying affidavit, and you've referred also to what was said in the founding affidavit. My question is more fundamental. This is an application for leave to appeal, correct?
Yes, correct.
So we must look for the evidence to resolve the appeal in what was before the High Court. Absent your getting permission for leave to adduce evidence on appeal, surely none of the factual allegations in your papers in the Constitutional Court can be taken into account.
Yes, so if I may also perhaps take the point one step further.
Sorry, but can you just answer that question? There isn't an application for leave to adduce evidence on appeal.
No, I might. There has been no application brought for leave at this juncture. I mean, I could take an instruction in response to that, but at this juncture,
I'm certainly not inviting that. On the assumption that there's no such application, then we must resolve the application for leave to appeal and the appeal itself, if leave is granted, with reference to what was before the High Court.
Yes.
And before the High Court, would it be correct to say that there was no evidence of the IDC's involvement in the appointment of Mr. Damons?
I could have a look at that, but Justice Toronto is certainly correct to say that the submission made at that point was the veto power which the business rescue practitioners had. So,
yes.
So I will have another look at the founding affidavit in those papers to see if there's anything, and respectfully come back to you on that.
Yes. On the assumption that there's no such evidence, would my understanding be correct that the presence or absence of that evidence will affect whether we can make any pronouncement on the validity of Mr. Damon's appointment, assuming we accept your construction of section 139.3? But it wouldn't be germane to the question whether the company, without the support of creditors, could have appointed Messrs. Tayob in January.
With respect, yes.
If I'm now going to just ask a question on the merits of the appeal, if we get there, and the construction of section 139.3. I don't wish to traverse the arguments for and against, which are in the heads of argument and which the SCA took into account. I just wish to raise with you one further consideration, which I don't think has been ventilated yet. If you look at section 139.3, you will see that when a practitioner, let's confine ourselves for the moment to resigns, it says the company or the creditor who nominated the practitioner makes the substitute appointment. Now, am I correct that your argument is that the phrase or the creditor who nominated the practitioner should apply not only to a creditor who has brought an application under section 131, but a creditor who has successfully brought a challenge under section 130? That's the essence of the argument.
That is the essence of the argument.
Now, if one looks at the section, subsection 3, one will see that the identity of the person who can make the substitute appointment is expressed in the singular and is on the face of it very clear. You either, at least on the SCA's interpretation, you either have the company itself, if it initiated business rescue under section 129, or you have a creditor who nominated the practitioner, and the SCA says, well, that's effectively the creditor who brought the business rescue application under section 131. I accept
Correct.
that the SCA pointed out the anomaly. It's not always a creditor. There can be other affected parties, but it made that correlation.
Yes.
But either way, which on the SCA's interpretation, you will always be able to know clearly who that person is. You will either go back to the company if it started under section 129, or you will go back to the applicant creditor if it was section 131.
That is so.
On your argument, if one extends the creditor component of subsection 3 to include the challenge under section 130, we would then have to go back to the expression in subsection 6 of 130, where it says the court makes the replaces the removed practitioner, must appoint an alternate practitioner recommended by or acceptable to the holders of a majority of the independent creditors' voting interests who were represented in the hearing.
That's correct.
Now that could be potentially a large body of people. If we take the present case, for example, it was the IDC, it was Western Dawn, which intervened, and it was a number of employees who may well have been creditors by virtue of unpaid salary. But just as the facts of the case don't really affect the interpretation. What subsection 6 involves is potentially a body of people, not a single person.
Well, when it talks about the holders of a majority of the independent creditors' voting interests, I mean, that would ordinarily be one set of persons who hold the majority voting interest. It's one person. It's not.
Well, why is it one person? Subsection 4 says of subsection 130, each affected person has a right to participate in this challenge. And so you could have a large number of creditors or a multiplicity of creditors.
Yes, if you're submitting to me, Justice, that there are two potential interpretations of 130 sub 6. The first is that the whole.
No, I'm not suggesting that subsection is at all ambiguous. All I'm saying is it refers to a multiplicity of parties, and then a determination of where the majority lies among them. So if your interpretation is correct, it would mean that you wouldn't have a clearly identified person to go back to. You would effectively have to have somebody, first of all, to appraise the voting interests, and the Act tells us elsewhere how you appraise voting interests. And then somebody would have to somehow convene a meeting of these people, and the result would not be the appointment by a creditor. It would be appointment by a vote of a majority of a group of people. Is that right?
Yes, on the assumption that a majority of the independent creditors' voting interest is necessarily a potential multitude. On the facts, it may be that it's a single person, because to talk about the majority of the independent voting interest can also be construed to mean it is the person who holds the majority voting interest, because there always will be someone who holds the majority voting interest.
No, I don't understand that. Why? If there are 5 creditors, each with claims of 20,000 Rand, who holds the majority interest?
Yes, so in that instance, as I'm saying, the interpretation then would be that you look at who the majority of them making up which would then be more than anybody else. If the aggregate of them constitutes the majority, then that's so. But in other cases, there will be one independent creditor who holds the majority. I'm just I'm not denying what you say.
Yes. So the sorry. Yes, but bearing in mind that the interpretation can't be affected by the facts of the case, there may be a clear case with a single large majority creditor. There may be other cases of a multiplicity of creditors. But it appears to me that your interpretation would have the practical implication under subsection 3 of section 139, that the phrase, the creditor who nominated the practitioner would have to become the reference to this body of creditors, and in fact, not one of them, but as it were, a majority vote of them. Would that be a practical and effective interpretation in the context of business rescue?
It is respectfully not only practical but purposive, because what happens at the point of section 130 is the company, having initiated the business rescue and having appointed the practitioners, has been superseded. Because what has happened at that point is the court is about to make a decision as to the fate of those 2, or in this instance 2, but of the business rescue practitioner appointed by the company. So in dealing with that, the fulcrum of power has shifted from the company to the creditors. And it is purposive and logical and symmetrical that at that point, the appointing authority should be the majority of independent creditors, because they are the most important component of whether the business rescue plan will be accepted and implemented. And
can
so,
understand.
Your 45
sorry.
is up, Mr. Simon. But
I'm sorry.
we were engaging you throughout. How much more time do you require?
Justice, I am in the hands of the court. I would like the opportunity to answer as best as I can all of the questions that are posed to me. If there are a lot of questions, I would ask for more time. I wouldn't like, respectfully, if I had a choice, and it's not mine, I wouldn't like to interrupt where Justice Rogers is going, because it's fundamental to the matter.
No, based on your own assessment of what you still want to say, which you feel you've not covered in response to our questions, what you yourself still want to say, how much more time would you need?
I should think there are, perhaps one of the judges would want me to address Justice Ranchod's order.
Yes, I am that judge. I would like you to address that question. Yes, please, Mr. Simon. But I'll wait for you to finish your engagement with my colleague. Yes.
Maybe Justice Madlanga, in this sort of never-ending kind of ball of string, maybe a half an hour, if you would indulge me to try and deal with everybody's questions.
Okay, let's say 20 minutes, and we'll revisit that when we get to the 20 minutes, to the end of 20 minutes. Yes,
thank you,
Rogers.
I appreciate it.
Sorry, Mr. Simon, unless you've got something more to say in response to my question, as the American politicians say, I'll cede my time. So,
I take your point, Judge, and I understand that. And my only submission to be made is, because the fulcrum of power has moved, it's just completely incongruous at this point to revert back to the initial appointing authority. It now needs to move forward where the wishes of the creditors predominate in the purpose of interpretation. That is my submission. But I'm not denying that one needs to identify who is that independent majority, and it would have to have been done at the Section 130 application stage for the court to take cognizance of who that creditor is. And as it turns out, on the facts of this case, there doesn't seem to have been any dispute that that's the IDC. But I have nothing further to add to your question.
If I may then, Mr. Simon, I share the concerns raised by my colleagues, Justices Rogers and Theron, but mine is a different one, and it's the question of what is Judge Ranchod's order, because Mr. Lowe says in his heads that this intervention by the court is not actually in terms of the statute. They resigned in the face of a Section 130 application. They weren't removed. What do you say of that submission? In other words, that resignation does not count as a removal in terms of Section 130. That is the submission.
Yes, respectfully so. That is my learned friend's submission to you. But may I say in response to that one must also look at this in context to see exactly what happened, and in a factual context and a legal context. So in the factual context, what we know here is and it appears from the answering affidavit in this application to you for leave to appeal. The answering affidavit explains the circumstances under which this consent order was obtained. So a number of factors are important. Firstly, all the affected parties as defined were given notice and were present in one way or another. We should assume that, otherwise the court wouldn't have been in a position to make any kind of order. It had to be satisfied as to that, and there's no suggestion that that didn't happen. So then at the last moment, what seems to have happened is that the parties, all affected parties, moved forward and avoided a decision by the court as to whether to replace by taking that decision, by presenting that court with a fait accompli. So the fait accompli which was presented to the court was in fact that they were to be replaced. So the argument of my learned friend is that because the court didn't actually issue the replacement order, that and recognize that and recognize the resignation, that is an insufficient compliance with the jurisdictional prerequisites to fit with Section 130 sub 6. My submission is that is respectfully not so, because firstly, the factual context indicates that all that happened was the parties by agreement, including the business rescue practitioners who were directly affected, accepted that they would be replaced. So if you look at the cases that my learned friend cites, Eek versus Parsons, the Buffalo City case, and the Valor case, now all of those cases establish two basic propositions, that perhaps more than two basic propositions, but they are these. Firstly, the court should not respectfully accept a consent order on its face, but should look at it with open eyes and consider its context. And some parts of it may be acceptable, other parts not for a court order. We know that Justice Ranchod's order begins that having considered the matter and heard counsel, he then went ahead to make an order. That's proposition number one. The second proposition that emerges from these cases is that the consent order must be related to the list which is before the court. And there is no doubt that in this instance, the list that was before the court was a dissatisfied creditor who wanted the removal of the practitioner so that new ones could be appointed. It's within the list. The third is that, and perhaps this is the one which my learned friend focuses on, that it must be a lawful order. And the examples, the best examples are these. In Buffalo City and Valor, the problem is that when the court was presented with a consent order, it was being asked to ratify what could not be ratified. And that is that procurement processes which were tainted and flawed were being accepted in the consent order and sought to be validated through the consent order. Now, the court would never have granted that order, even if the matter had been heard. And it's unsurprising in that context that the court then declines to make a consent order because it would be validating unlawful conduct. In this instance, all that's happened is, as a matter of fact, the question of whether a replacement must occur has been substituted by consent. And the court could have made the order replacing them if it needed to, but it didn't have to because it was agreed. So the replacement occurred as a fact. So to suggest that the jurisdictional prerequisite is absent is a bridge too far, respectfully, for the respondents. What was happening here with the concurrence of all the affected persons in the business rescue was that they would go and needed to be replaced. To seize on that as an answer on the basis that the court order was ineffective is respectfully not an argument which is tenable. And this case is completely distinguishable from the cases which my learned friend cites. And here, there would be nothing to stop the replacement, and it would have occurred, obviously, respectfully, as an inevitability if the matter had proceeded and was accepted by the business rescue practitioners to be so. So they forestalled it by their resignation, creating the atmosphere for the appointment to take place in terms of Section 136. The argument to the contrary, respectfully, is just a substance over form, and it is a form over substance, and it is, in fact, respectfully misdirected. Those are my submissions.
Yeah, thank you. Thank you.
Mr. Simon, you may have answered some of the questions that I would like to raise. You'll bear with me if that is the case. I just want to get clarity. This was a voluntary process where the company made an appointment of the business rescue practitioner under 129, and the IDC objected under Section 130. Then the court made the appointment. Now, the question that I want to raise is, when Mr. Mahier resigned, does the resignation of Mr. Mahier change the nature of the process from one of voluntary to involuntary to allow a creditor to make the appointment of the substitute BRP?
No, my lady, the nature of the business rescue proceedings never changes. This is a voluntary business rescue, and it remains a voluntary business rescue. It never becomes compulsory, and all that happened by the invocation of Section 130 at the instance of the IDC is that the appointed business rescue practitioners by the company at the inception of the business rescue needed to be reviewed. Those business rescue practitioners need to be set aside. And on the recommendation of, if one looks at the wording of Section 136, is the new business practitioner recommended by or acceptable to the holders of a majority of creditors' voting interest who were represented in the hearing is taken into account with regard to the appointment. And then what happened, as your ladyship knows, as you point out correctly, is that Mr. Mahier was then appointed and Mr. Moniela as well. And the question then is, what happens when Mr. Mahier resigns? Because he was one who was appointed at the recommendation of, at the instance of, the majority of creditors. Now, is it they who make the next appointment, or does it revert backwards to the company which made the initial appointment? And our submission is that upon a proper interpretation of Section 139(3), that when the court talks, or the statute then talks about the nomination, because the SCA respectfully had it right about the two pathways to business rescue. And the symmetry requires that absent a Section 130 application and an appointment, there would be a clear line between Section 129 and Section 139(3, because then if you look at 139.3, the company, so in that instance, so there are two possibilities here. The company or the creditor who nominated the practitioner, as the case may be, must appoint a new practitioner if the practitioner dies, resigns, or is removed. The company there is clearly the company acting under Section 129 who appointed the practitioner in the first place. And then it is that practitioner who dies, resigns, or is removed and needs a replacement. But the other possibility is the creditor who nominated the practitioner who must appoint a new one, which is then the compulsory, which is not the case.
Yes. Mr. Simon, if it's voluntary and the person resigns, surely the power should remain with the company. Why do you say it doesn't? Because of the fact of the involvement of the creditor. And when you respond, also have regard to the, tell me why the legislature deemed it necessary to insert the proviso in Section 139.3, which says, subject to the right of an affected person to bring a fresh application in terms of Section 131B to set aside that new appointment. What does that mean?
Yes, if I can deal with that second question first. Yes. If I may deal with the second question first. The reason why that tail end, Section 131B, is there is that if the company is the person making the appointment absent a Section 130 process, if the company is that person, and in a voluntary, Section 131B always applies in the company's appointment to allow for the removal of the company's appointment. But all of that operates absent Section 130. So there are two clear lines that happen. One is the Section 129 appointment. Let's leave out Section 130 for the moment. The company appoints a practitioner, the practitioner dies. In that instance, Section 139.3 says, well, the company must then reappoint, exactly as you suggest. The other line into this is that under Section 131, the court appoints the practitioner nominated by the petitioning creditor who seeks the business rescue. There, if that one dies after the court has made it, it is the nominee creditor who makes it again under this section. He's not affected by Section 131B because by definition, Section 131B in the tail only applies to a company's appointment. It never applies to a compulsory appointment at the instance of the court. So now we get to the a novus actus that happened in between Section 129 and 131 and 139.3, which is 130/1B application. In that application, everything changes because a sea change takes place, because the creditors are the people who now take over the recommending and appointing function. The court will not make an appointment without their permission. So what has happened is the interposition of a complete novus actus, which has changed things qualitatively forever. And you can never go backwards to the company because the creditors are now involved. It's at their instance that the company's appointment was removed. It's that their instance, recommendation and approval, that a new one will be appointed. There is no merit whatsoever, respectfully, in going back to the original position of the company's appointment. Things have changed. Things have moved on. They can never return back to the company. And the company's role in a business rescue post the appointment of a practitioner is very limited. It's auxiliary. It cannot do anything without the business rescue practitioner's permission. The business rescue practitioner can remove directors at will. So my submission to you is it's retroactive, it's retrogressive to go backwards and doesn't take account of the purpose of the Act or Section 130. But those are my submissions to you.
Thank you.
My questions were covered by Justice Majid and Justice Rogers partly. But it would appear that on the resignation of Kloppers and Knoop, the settlement order that was made, was it between the IDC and the union, and the company was no longer involved?
Yes. So well, everybody was present. As I understand the answering affidavit here, everybody was present. All the affected people were present, and it was at the instance of the union that the additional appointment, which became that of Mr. Maniela, was introduced into the settlement arrangement. But it was the IDC's nomination of Mr. Murray which carried the day. It wasn't the company's recommendation. It was the IDC's want, its wishes and its desires and its support for him that carried the day.
Yes, no, I think you've covered the other questions that I wanted to raise. Thank you.
Thank you, Justice.
Simon?
Oh, sorry.
Please proceed. Please proceed, Justice. Oh, thank you.
No, I was asking if there are any further submissions.
I'll just come in as a sweeper, as they say in cricket, Mr. Simon, to tie up a few loose ends. The one that we haven't raised with you yet relates to jurisdiction. The equality argument that is being raised by the applicants in this court was not raised in the High Court, was also not raised in the SCA. On what basis is it being raised for the first time in this court?
The only submission I can make in that regard is in order to cover both bases in the Paulson case of applications for leave to appeal, I need to show you it's a matter of public interest, essentially, that the court should address and is arguable. I do also rely on the constitutional implication, and I do agree, my lady, that there's nothing to suggest in this record that the equality argument was raised in any court before this. But again, it flows as from the issue of interpretation, because on section 139, it's part perhaps more of, it's not a challenge to the statute, it's a way to interpret the statute. So what we're suggesting is, in the interpretation exercise, what needs to be taken into account is that it doesn't make any sense that you would allow a creditor who finds itself in two different positions to have two different kinds of remedies and rights. So if the creditor brings the compulsory application under section 131, he nominates, or he or she or it nominates, the business rescue practitioner which the court appoints. Section 139(3) carries that through symmetrically and says, well, if that person dies or is replaced, they would make that appointment. But now, if you take the creditor who wasn't fortunate enough or coincidentally happened not to be the creditor who caused a compulsory business rescue because the company preempted it by putting itself in business rescue. If you were to say to that creditor, he or she or it has rights in regard to the appointment under section 130 sub 6, but not under section 139(3), unlike its counterpart being the creditor who nominated in a compulsory, then you have a discrimination which is just not justifiable. It's not rational. It doesn't respectfully make any sense to treat that same creditor in two different positions differently. And that's the extent of it. But it's not a challenge to the section itself. It's rather the purposive way to interpret it in accordance with section 39(2) of the Constitution and the various provisions, such as 7K, for example, of the Companies Act, which says that when the court is faced with a decision in regard to the business rescue, it should look at and balance the rights of all creditors concerned, all interested, affected parties concerned. And that, as we've shown you in one of the cases we've referred to, certainly includes creditors. So I can't take that submission further. Those are my submissions to you on that point.
Yes, Mr. Simon, you just referred to section 130 sub 6.
Yes.
If I understood your argument earlier, your submissions in response to my brother Justice Majid's questions to you about the order of Justice Ranchod, does section 130 sub 6A and section 131B arise in this matter? Because if I understood your argument correctly, the order of Justice Ranchod was not made pursuant to section 131B or in terms of, or read with section 130 sub 6. It was made on the basis of a consent agreement between the parties, and it was giving effect to what the parties had agreed to.
Justice, you did refer to section 131B. In terms of section 131 sub B, the court can set aside the appointment of a practitioner. In terms of section 130 sub 6, if the court makes an order, setting aside the appointment of a practitioner, it must, under 6A, appoint an alternate practitioner. Now, the jurisdictional prerequisite is the setting aside of the order. If that's the question you're raising, and if you're suggesting that the consent doesn't amount to it, I'm saying it does amount to it. My submission to Justice Majid is that all that happened here is that there was a preemption of a finding which would have been a legitimate finding by the court for their replacement. That was no longer necessary to decide.
Yes, because it was not necessary to decide, the court did not exercise its powers in terms of 131B. A court can set aside an appointment on the grounds that the practitioner does not satisfy the requirements of the section, is not independent, and lacks the necessary skills. The court did not invoke any of those grounds. And it did not invoke its power in terms of 130 sub 6.
Because it was accepted.
Because the practitioner had resigned.
Yes, because it was accepted that there would have to be a replacement. There was no need. So respectfully, it's an over-technical analysis of the section which is adopted by my learned friend, in which he suggests that they actually have to find it rather than it be agreed. And that isn't the way consent orders work. All consent orders follow upon a list in which some facts are accepted. And once they're accepted, the court doesn't have to decide them. It doesn't mean that it never exercised its mind and discretion in regard to its jurisdictional requirements. That's the difference between the argument between my learned friend and I. It's that it was a given. You don't have to say it as a court if it's a given.
Okay, Mr. Simon, this is my difficulty. Where does it appear that the court accepted that the jurisdictional facts set out in subsection 131B had been met?
Well, if one looks at the order, my lady, you'll see a couple of things about it. The first is that the court had given consideration to the parties, to the papers and the submissions of counsel. So I'll just find you that reference, my lady.
Yes, I have the order in front of me and I can see that.
Good. So what it says is that the learned judge had reference to the papers and to the submissions of counsel in accepting the order. It recognizes the resignation of the practitioners. In other words, that they needed to be replaced. It knew that the application was brought in terms of section 100.
Before you go any further, that section 131B gives the court the power to remove a practitioner on the basis of sub-Roman numeral 1, 2, and 3. Now, before the court could exercise its power in terms of that section, before the court could set the appointment aside, the person resigned. And if we thus go to 130 sub 6, when the court granted the consent order, it was not exercising its power in terms of 130 sub 6 because it was not considering an application. The court was not called upon to consider whether or not the requirements in B, Roman numeral 1, 2, and 3 had been met.
My lady.
The court was giving effect to a consent order between the parties.
Justice, the submission we have made in our heads is that resignation is surrender. So what the court did is it said in its court order that I have considered this application under section 131B. I know that that section requires two things. If the practitioner is to be removed, the practitioner must be replaced. There are two aspects to this. So as far as the removal is concerned, they are going. I don't have to make a finding on that because they're going. But now what I do need to do, because the application before me is in terms of section 131B and read with 136. So what I need to do is I can't leave it with nothing. I'm going to make the order pursuant to this application. It's part of the list and it's one which I can lawfully make. So my submission to you is that respectfully, you are right that there's nowhere in the order where he says, I'm going to remove you as such. But the reason why I'm saying that it doesn't matter is that it was accepted and he acknowledged that acceptance through the resignation. So it doesn't, you know, if your case is so powerful for the removal, if the case is so powerful for the removal, that they capitulate and surrender and render it unnecessary for you to make that, to actually make the order for replacement, because it's going to happen. That it's respectfully not correct to then assume that the jurisdictional prerequisite is absent. The distinction that I draw is that it's already there and conceded, and that's why it doesn't matter.
Yes, I hear you, Mr. Simon. My last question is a follow-up to, or is related to the question that Justice Rogers had posed to you in respect of section 139 sub 3. Does the singular, the use of the singular creditor in 1393 not suggest that the act itself says that it can't be a multiplicity of creditors who are then entitled to a point?
No, because a creditor, to refer to a creditor there is just a generic term. It's more specific in section 130 sub 6 with regard to the appointment, is that the more close definition of what creditor we are talking about here, and creditor here is used generically, it's the majority of voting interest creditors. And you will note that this
Simon, I have a difficulty with that argument. We cannot say that the use of singular or plural has no significance. The use of creditor in the singular and creditors in the plural has no significance in the act, and it should be taken interchangeably.
Justice, all I can say is respectfully, my response to that is we've cited a number of cases which talk about statutory interpretation not being an act of peerage at particular words, but must be purposive and in accordance with what is intended to be achieved by the act. Creditor here, in my respectful submission, is a shorthand reference to the one who is the nominator. And I've submitted to you that the nominator here is the majority independent voting creditor. And I respectfully submit to the contrary, but your ladyship will determine the matter in accordance with the manner in which she sees fit. May I just say this? Just on this question of singular and plural, you'll note that the company, when purporting to resolve appointed 2 business rescue practitioners. If it was supposed to just replace Mr. Murray, it could only have appointed 1 for what it's worth. What I'm suggesting is that what we're looking for here is a principle. And the principle is that when Section 130 comes into play, the important appointing authority, clothed with power and with the right to determine the identity of the practitioner, is among the class of creditors. It is not any longer the company by resolution. That's my central submission.
And my last question relates to an issue that Justice Matlanga had raised, and I'm not quite sure what your answer was. You may have answered, but I may have missed it. Is the validity of Darman's appointment an issue in this matter?
Technically, it's not an issue, because what is before you, pursuant to the SCA's order, is whether the company could validly, by resolution, appoint the substitute practitioners. The conceptual argument, as I put to Justice Madlanga, involves a consideration of who is the appointing authority on a proper interpretation of the sections. The factual component of it, I've indicated in my argument, is there. You will either accept the reply or you won't accept the reply. But in the founding affidavit, which you may say cannot expand the case that was made in the founding affidavit in the High Court, and I undertook to look at that.
Not just the reply, but also what Justice Rogers raised with you, which is whatever new material there may be, even in your founding affidavit. So not just the reply. I'm sorry,
Yes. Thank you, Justice. I intend to, I said to Justice Rogers I would revert him on whether there's anything in the High Court founding affidavit, answering affidavit, which may be of assistance, and which I'll do shortly after my learned friend perhaps.
I think I'll be surprised if you find anything. I went through that entire affidavit. There was somewhat of a disclaimer that says, to the extent that we do not deal with some of the facts, it should not be taken as if we admit, and so on and so. But this was something quite crucial, because in paragraph 6.12, in so many words, Mr. Tayob says, they said they were acting qua company. They said they were acting as the company. In so many words, that's something quite crucial in which one would have expected a response to. I'm sorry, my sister, is still your
Thank you, Justice. I appreciate your comments and take them on board. I'll have a look, and if you say so, I'm sure that will prove to be right. But I'll have a look at that as well.
Thank you, Mr. Simon. You've addressed all my questions. Thank you, Justice Matlanga.
Let's take an adjournment until 11:36.
Court will adjourn until 11:36. Please note that during the adjournment, you are welcome to switch off the video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 11:36. Should you exit, you may use the same link to rejoin the hearing.
Justice Theron, are we all here, including counsel?
Let me just give a final check, Justice Matlanga. It looks like we are all online, Justice Matlanga.
Thank you, Justice Theron. Mr. Simon?
Justice, if I may just take another 5 minutes. I've had the opportunity now to talk to the other representatives of my team who are in different places in the country. If I may just make, and I shouldn't be much longer than 5 minutes. Justice, just a few odds and ends. So firstly, just a typographical error to note. In volume 2, page 130, which is our notice of motion.
Small typos that are clear as to what was intended. Please don't worry about that. Please,
yeah, because this may just be important because we asked for,
right, okay.
It incorrectly refers to the second and third respondents. It should in fact be the first and second respondents. So it does make quite a big difference.
I remember looking at those names and saying, how do, and being confused.
I'm sorry about that. That's an error.
All
I'm
right.
sorry. If you would please read it that way. The other thing is that with regard to what was said, Justice Theron raised the issue, and I think some of the other justices raised it as well. The question of what was said in the High Court in regard to the position that the problem there was that the company had passed the resolution and the argument was a veto right. It wasn't that the IDC in effect had made the nomination. If I may just say that that's correct. That's what was said in the founding affidavit. But can I just say this, which is quite important, Judge? What that was a legal concession. It was a legal concession which recognizes that the company could make it, but the deficiency was that there was a veto right which hadn't been adhered to. But a legal concession is not binding going forward. It may be wrong in law. And if I may refer you to what this court said,
I think you please accept that we know the principles, Matatiel and so on.
That's exactly the case I was going to refer to. Thank you, Judge.
Yes.
And just with regard to the Ranchod order, Justice Ranchod was specifically aware of the fact that the application was brought in terms of section 131B and 130 sub 6. If I could refer you to volume 1, paragraph 5.5, page 14, where that is quite clear on the papers. And the final point I want to make is with regard to the question of singular versus plural. If I may just respectfully point out that if you look at section 139.3, it's the company or the creditor who nominated the practitioner, but there's a qualification to how to apply it to the particular facts because it's in the words as the case may be. But to read a creditor literally there as only relating to one as opposed to a body, my submission is that's not respectfully a commercially sensible or purposive interpretation. And it would mean that if you adopted the same sort of policy to 130 sub 6, where it said there that the person must be acceptable to the holders of a majority of the independent creditors' voting interest. That's plural. And as Justice Rogers correctly pointed out, you look at interpretation not by reference to the facts, but what if the facts were that there was only one holder of a majority, which is also conceivable? So what I'm submitting is simply that it depends really on the proposition in context, the interpretation that we're dealing with. And here, I don't think the fact that there's a reference to creditor only necessarily excludes the possibility that it may be a body of creditors or more than one, as under 136, finding its way into section 139 sub 3. So those are my submissions, Justices.
May I just, Justice Matlanga, ask Mr. Simon, when you refer to the Ranchod order, you made a reference to the record. I missed that. Could you just repeat that, please? Volume 1, you said, page?
Yes, thank you, Justice Majid. Let me give that to you. It's volume 1, para 5.5, page 14. That identifies the basis on which the application was brought. It doesn't go further than that, but that was obviously in Justice Ranchod's mind.
Thank you.
Thank you, Mr. Simon. Mr. Lowe?
Thank you.
Justice, thank you so much. I would want to deal with, at a high level, with our learned colleagues' eloquent and lengthy argument, which commences, as good advocacy does, with a concession, and then with a trivializing qualification of the concession. What we have in this case is we would submit a completely different case from the one that we find that was debated in the High Court. The facts that were contained in the High Court application actually demonstrated that as between the present parties, there was agreement, complete agreement, that it is the company that does the appointment, and the only question was where the company's mind had been replaced by the outgoing BRPs, so that the outgoing BRPs actually acted as the company. So there was no issue about interpretation. The reason why this is important is that we now have a completely sanitized case that stands proud, it would appear, from the facts, and where our colleagues argue the following. They say, well, you are not actually entitled to your order. Normally, you would have been entitled to a declaratory order in the form that the Supreme Court of Appeal gave it, but you are not, because of the events that occurred before His Lordship, Mr. Justice Ranchod, and the events leading up to that, and the events leading after that. So we are not actually dealing here with the resignation in the normal course of an appointee of the company. But if you look carefully at what happened in front of the High Court, but not the High Court in our matter, but the Ranchod Court, to call it that, you would have seen that over there was a genetic change in the type of business rescue that we have.
Colleagues, sorry, Mr. Lowe. Colleagues, do not forget that Mr. Lowe said we may engage him right from the beginning.
Yes, thank you. I will continue that, Justice. So what we have is the argument that normally my client would have been right, and this when an appointee of the company resigns, the company obviously, in terms of Section 1393, would have the right to appoint. But they read a lot into the word creditor in Section 1393. And they say that genetic manipulation took place, a change took place, a genetic splicing perhaps took place in the events before His Lordship as a Justice Ranchod in the High Court and after that. Now, our difficulty with this argument is not necessarily that the argument on the facts, or that the facts that our colleague puts forward are necessarily wrong. The point we make is we just don't know, because those facts were not explored in the High Court. The High Court did not consider these facts. The Supreme Court of Appeal did not consider the facts. To make matters worse, the IDC is not even a party to the case. As we say in our heads of argument with respect, this really is a proxy war that is being fought between the company, Shiva, represented by its directors, who are not parties here, and the IDC as an independent creditor who is not before you. So there's a proxy war going on between BRPs who believe that they've been properly appointed on the one hand, and BRPs who now admittedly can no longer say that they were properly appointed. What one can see is that even the representation of Shiva Uranium as the first applicant in this matter is questionable, because as has correctly been pointed out, Regulation 127 of the company regulations makes it clear that that's now 127.3, makes it clear that a junior practitioner, which Mr. Monyela is, has very limited powers. It states in B of 127.3 that he may not be appointed as a practitioner for any medium or large company because he's a junior practitioner, or for a state-owned company unless as an assistant, and that's of substance, as an assistant to an experienced senior practitioner. So there's even a question whether Shiva is before the court at all. Now, if all of these facts are taken into account, and it is recalled that the only list between the parties in the High Court was not, is it a creditor or the company, but the company represented by a BRP or the directors. That was what the fight was about. And that is why we say it is just not the right case to jump over the facts and to have an academic argument about the proper interpretation of section 139.3. The next point that we would want to make...
Sorry, Mr. Lowe, can I just jump in here for a moment? I appreciate that the facts concerning the IDC weren't ventilated in the High Court, and that seems to me to concern the question whether Mr. Damons was in substance appointed by the IDC. But it seems to me that in the SCA, the order that was granted, the focus of the argument was whether Messrs. Tayob and January were validly appointed. And the SCA said yes, they were, and that was based on a particular interpretation of section 139.3, that the power of substitute appointment reverted to the company, because it was a section 129 initiated process. That view of the law didn't depend on the facts. Nobody, the IDC's role is irrelevant to that question.
Indeed.
And the argument was made, and the SCA answered it. The argument was made on behalf of your opponents there that 139.3 vested the power of appointment in the creditors who had launched the challenge under section 130. That argument was made and it was rejected.
Indeed, that is so.
Sorry, just to complete it, if that argument had been accepted and your argument had failed, the SCA would have had to found that Messrs. Tayob and January had not been validly appointed. One might not yet know that Mr. Damons had been validly appointed. That would be a different question, but it wouldn't affect the order concerning your clients.
The case migrated from a binary choice between two potential sets of business rescue practitioners to the Supreme Court of Appeal. And Justice Rogers, you would have seen that during the course of argument, my opponent at that point proposed to the court that instead of dealing with the appeal in a manner that would leave everybody unsatisfied, effectively, for the court to make a declaratory order, which the court then did. And we have no objection and no quarrel with that whatsoever. Because the focus then shifted from a binary choice, either you or you will be the business rescue practitioner, to a simple question whether my client was properly appointed as business rescue practitioner. And for that, there was only one common cause fact that had to be taken into account. Justice, you would see that the Supreme Court of Appeal did not get into what actually happened before the Ranchod court. Not at all. It accepted one fact, and that is that there was an application by the IDC for the removal of Knoop and Klopper, and that they resigned. And to that extent, the question of genetic engineering was dealt with.
But in a sense, the SCA assumed, without so deciding, that Mrs. or that Mr. Murray had been appointed pursuant to section 130. Well, and it answered the legal question to say, well, even if that is so, when Mr. Murray resigns, the power of substitute appointment reverts to the company.
Yes, the focus, if I may just say that, Justice Rogers, you would have seen in the founding affidavit in the High Court, it was accepted, although there was a question mark whether it was validly done, but it was accepted that that order of Ranchod J stood until set aside. For what that is worth, that was the way that the case was accepted, was presented rather. In the Supreme Court of Appeal, the focus fell on the legitimacy of my clients as business rescue practitioners, following upon the resignation of Mr. Murray, assuming that Mr. Murray had been properly appointed in the first place. And that was the question. What we now face is something different. We now face an argument that what happened in front of His Lordship, Mr. Justice Ranchod, or perhaps not in front of him, but before the case was actually determined, no, actually not determined, but before the order was made, that is where the focus must fall, because that will show you that genetic engineering took place. They call it a novus actus interveniens. What we understand it now to be is a factual inquiry. So what I understand our colleagues to be saying is, well, normally, if a company appointed business rescue practitioner resigns, the company in terms of section 139(3) has the power and the exclusive power to appoint the replacement business rescue practitioner. But, say they, in this case, it's different because of the novus actus interveniens. And we have a difficulty say that those facts were not properly explored in the High Court. If one compares the affidavit in the High Court with the founding affidavit in the application for leave to appeal to this court, and of course what is stated in the replying affidavit, you see there's a massive disjunct. There's a
but the legal point that if there is a section 130, let us call it an actus interveniens, causes the power of substitute appointment thereafter to reside with the majority creditors rather than the company. That legal argument was advanced. How it would play out on the facts if that argument was correct is something different. But the legal argument was raised in the SEA.
Yes, absolutely. And
if it was a correct legal argument, then it would... If it were a correct legal argument, the SCA said it wasn't, but if it were a correct legal argument, then admittedly your client wasn't appointed by the majority of creditors who brought the section 130 challenge.
The declaratory order would not have been made.
Yes.
It's a legitimate argument we would submit insofar as the Supreme Court of Appeal, the case that it dealt with, because it relied only on what was stated and set out in the founding and answering papers in the High Court, where one finds that it was this dispute about, yes, it is the company, but which company, the BRP company or the Board of Directors company? That's that dispute. They abandoned that argument, and we agreed effectively that the Supreme Court of Appeal should test the argument of genetic manipulation, but not novus actus interveniens, because we now find that the focus on, insofar as a factual, on the factual basis, on the facts are concerned, now not concerns the resignation, with the greatest of respect, of Mr. Murray, but the resignation of Knoop and Klopper. Just to confuse issues, because there are these two sets of resignations. And in the Supreme Court of Appeal, the focus fell on Murray, but now it seems that it must go back to the Knoop and Klopper resignation, because that is where they say the genetic engineering took place and the whole stream changed from a company, process to one that is a creditor process. And we say, no, we can't see that in the legislation.
Mr. Lowe, if Mr. Murray was appointed after the objection by the company, now after his resignation, what happens to the interests of IDC? Who is there to make sure that the creditors' interests are taken into account during the process, if one says the company retains the power to appoint the BRP?
Justice Mhlantla, I believe that you raised with our colleague, and I'm trying to remember. I don't want to.
It was the other way.
There is a check and a balance, or a balance for this, and that resides in the proviso of Section 139(3). So if my client is correct, or clients are correct, and they properly appointed, then what remains is the right for an attack on their appropriateness to be made in terms of Section 139(3), reverting back to Section 131(b), where the power is given to anyone, and it's not only a creditor, but to any affected person, to challenge their appointment. But then reasons have to be given, and as we know, the challenge in Section 131(b) is, as Justice Turana pointed out a few times, that the appointee does not satisfy the requirements of Section 138, is not independent, and does not have necessary skills, and so forth. And that is the check and the balance.
Mr. Simon says once there's a challenge, you cannot go back to the initial phase. Once there's a court process in place that ends up making the appointment, you can't go back and then say the company retains the power because there was this intervening act that took place.
Well,
what do you think?
That would have been a nice try if it's true that only a creditor can challenge the appointment of a business rescue practitioner who was appointed in terms of Section 129(3)(b), namely by the company, appoints a business rescue practitioner and so forth. Because Section 131 makes it clear that an affected party or affected person can challenge the appointment, and not only a creditor. So the class of entity who can challenge is greater than a creditor. What is true is that a creditor must be satisfied with the person who is then eventually appointed by the court. Let's assume, for example, it's a cohort of employees, a trade union perhaps, who do not believe that Mr. X is the appropriate person to be appointed as a business rescue practitioner, and not qua creditor, but qua employees, because they're affected persons, they can do so. They then approach the court and they say, we can't have Mr. X, we're not creditors, but we just believe that he is the wrong person for whatever reason, and they can then prove it. What then happens is that they can, of course, suggest in their application a person, but the court will look, and this is very important to note insofar as our colleagues' argument is concerned, Section 130(6)(a). I think if I can just for a moment pause on that. What then happens? Now, in my example, it's not a creditor who brings the application, but let's assume a group of employees. The court then, if he has if the court has found that the appointed person should not be, that's the person that's appointed by the company, should not be the practitioner, must appoint, it says, an alternate practitioner who satisfies the requirements of Section 138, always says so, who is recommended by, and this is important, or acceptable to. And now comes the qualification, the holders of the majority of the independent credit voting interests, and here it is, who were represented in the hearing before the court. Now, Justice Rogers pointed out that what you have here is a class that is unclear. It's not a simple creditor. It is not anyone that you can, with great certainty, in a messy case where there might be many parties, identify. We know that in an application in terms of Section 130, all affected persons must be notified of the application, and then they can be heard or not. But it goes further here. It says, dependent creditors' voting interests who were represented in the hearing before the court. So if, for example, you have no creditors taking part in the case, no representation before the court, there's only a group of let's say, employees who brought the application, then the court will appoint, and then notionally there must then be a hearing. But who's then going to appoint? Because there was no creditor who was represented in a hearing before the court. So it is difficult, but all we say is that insofar as this point is concerned, that there is no incongruity insofar as reading creditor in section 139.3, that is now after the disjunct of the or in the sentence, the company or the creditor who nominated the practitioner. There is no reason to read creditor there, referring back to a creditor who must be, who either recommends or finds the appointee of the court in terms of a section 136 acceptable. So with respect, if I may then just quickly go back to 139.3, we say it's completely binary, and the legislature actually produced a very finely tuned instrument in these different sections and how they hang together. Because on the one hand, it is a voluntary process, and it stays a voluntary process. Our colleague agreed that all the way through it remains a voluntary process. On the other hand, it's a compulsory process, which is engaged not necessarily by a creditor, I suppose mostly by creditors. In my experience, they are creditors always, but it could be an affected person who places the company in business rescue. It's through a court order. And importantly, when one then looks at section 131, which is the court-appointed process, the compulsory process, here one finds, interestingly, that in section 131.5, after court has placed a company under supervision and in business rescue, it goes on to say, the court may make a further order appointing as interim practitioner a person who satisfies the requirements, once again, of 138, and who has been nominated by the affected party. Who applied, and it goes on, and then there is a ratification process that is built in, showing clearly that the majority creditor or holder of the independent creditor's vote is not the necessary only applicant for business rescue in terms of section 131. So what the importance of this is, the word nominate. Nominate is found only in two places in these series of interlinked sections, and that's section 131.5, and then again in section 139.3. So in section 139.3, where we have the division, company or creditor, but not any creditor, creditor who nominated. Hence the authors of Hennosberg saying, well, creditor there must be read as the person, the affected person who in the first place nominated the practitioner, because it's not only a creditor who can make an application in terms of section 131 and nominate, but be that as it may, the importance now is on the word nominated. And our colleagues say, quite correctly so, that nominated must be read in terms of its ordinary dictionary meanings and so forth. What we point out is might be, but the legislature in this finely tuned instrument of business rescue practitioners uses the word nominate here in section 139.3 and only at one other place, which is 131.5. And there's the link. So what we say is that nominate, as used there, qualifies, of course, creditor, but creditor can't be the right word. It must be affected person, as Hennosberg says, and as the Supreme Court of Appeal found. And if that is so, it is then either the company or the affected person who nominated. And then we have the binary system running all through it. And then there is no place for a genetic manipulation, that we can say that we deal with a voluntary process, but there are some things that are now grafted onto this process. And that is that the decision to appoint a replacement in the face of a resignation is taken away from you and is given to a creditor. On a perhaps more elevated point, we do not agree with our colleagues that the purpose of, not the purpose, that there is a pendulum swing that takes place after a challenge, a contestation in terms of section 136, even if the contestation works out into a quagmire like we have in this case, that there is a swing that takes place towards the independent creditor, the majority independent creditor. We say no, we don't see that in the legislation.
Mr. Lowe, I think I missed your landing with regard to creditor in 139.3. So are you saying creditor there means affected person?
Yes, as the Supreme Court of Appeal said, on the back of also Hennersberg, who's the only commentator that I'm aware of. Yes, indeed, creditor is a subcategory of,
because the mover initially may well not have been a creditor.
Precisely, yes. And that's the only slip up that we can find in these finely tuned and finely honed and interacting set of.
The creditor was not a creditor.
Yes.
A creditor may well not be a creditor. Okay.
And if I may conclude with the following, unless there are specific questions, is this. I think the main difference between us and our colleagues is that our colleagues, in this proxy war, fighting for, it seems, the IDC, argue that business rescue, when it gets into this process of genetic manipulation, things change and there's a swing towards the creditors or the body of independent creditors. We say no, that is incorrect. The independent creditors are given certain special rights, and those are, most importantly, to vote for the business rescue plan in terms of section 150. There is, and insofar as that is concerned, that's what they do. But the importance of this piece of legislation, Chapter 6 of the Companies Act, which makes it different from anything that went before, and certainly liquidation proceedings, is that there is not an exclusive focus on the creditor as entity. There is, of course, you take into account what the creditor's interests are, but so do you insofar as the company, meaning the shareholders, and the employees. So what we have here is a triangular situation, 3 sets of rights that have to be taken into account, and not only those of the creditor. And it is against, as we understand, the very interesting underbuild of Chapter 6 of the Companies Act to say that there is a swing of a pendulum that takes place towards the creditor, and then everything shifts, and you must then interpret a benign section, section 139.3, by not only changing the word creditor, but actually reading creditor, reading it in the plural, having all of the difficulties of identifying who that might be, and saying, well, that group now has the sway, insofar as this important decision of who appoints the business rescue practitioner. So what we say in a nutshell is we believe that the Supreme Court of Appeal judgment is correct in every single respect. It is a well-crafted, hugely insightful judgment that brought together disparate arguments at that point, made a lot of sense of them, and also of the facts that were before the court. And we just simply, with the greatest of respect, cannot find anything that is wrong, objectionable, or that could in many ways have been crafted better than the judgment of the Supreme Court of Appeal in this matter. And those are the submissions, Justice.
Mr. Lowe, can I just take you to the SCA judgment while you're dealing with that at 153, volume 2 of the record, page 153, paragraphs 11 and 12. Because I just want to check if I understand this correctly. Paragraph 11 from the Merva JA says, in the answering affidavit, the respondents contended in the court of call that in appointing a substitute, the board had to act with the approval of the practitioner of Shiva, and that such approval had not been obtained. In other words, that's the veto power point.
Yes.
And in the main, the contention was based on the provisions of section 1372 of the Act. Now we know that section says that company directors must continue, and the company and business rescue must continue exercising their duties, but subject to the direction of the business rescue practitioners. And then this is the important part. The court of quo based the dismissal of the application on the acceptance of this contention. In other words, as I read it, and just check, tell me if I'm reading it wrong. As I understand it, that was the limited issue before that court, the veto power, based on section 1372.
Yes, indeed.
And then the court says, before us, the respondents raised a new argument. They submitted that only the IDC had the power to appoint a substitute for Mr. Murray to the exclusion of the board and so on. And then the learned judge says, as I've said, however, the central question is whether the applicants are correct that only the board had the power to appoint them as practitioners for Shiva. So it does seem to me that the case had shifted in the SCA already, but
yes.
Centrally the question that was determined is the one that you say is the correct one.
Indeed.
Now the second and the last part that I'd like to take up with you is again this Ranchod J order, which intrigues me, because Mr. Simon seems to suggest that there had been a tactical retreat in the consent order by making the consent order. But it does seem to me that tactical retreat or not, before section 130 sub 6 can kick in, there must be one of 131B of those three must be present. In other words, the court must make a ruling. The court must make an order removing somebody before replacing another. It's almost self-evident, but does that argument that this was a simple tactical retreat and it does not matter, can that ever mean that that section 130 sub 6 can become relevant in those circumstances?
We heard two arguments, and one very graphically, my colleague called it a surrender.
Yes.
Well,
I'm being more euphemistic. I'm calling it a tactical retreat. But anyway, it's probably the same thing.
Tactical retreat maybe implies that there will be another attack, but surrender means it's over. We would suggest that, first of all, there's an issue on the facts. Was it a surrender or was it not? We don't actually know. But the more fundamental point is the second point that our colleague made in this regard. He said this is merely form over substance. What had happened was what the IDC set out to achieve, it achieved. Maybe not through a court order, but through this surrender. Now, we have a quarrel with that, as you would have seen in our heads of argument and our argument itself. The order of Ranchod J at page 196, our colleague quotes from it and he says, well, it records that the court had read the papers and heard argument. Well, I don't know whether that happened or not, but it doesn't matter. It's in the formal, normal form of a consent order. What we do know is that it is not recorded. It does record that the resignation had taken place, but it does not record any of the requirements of a court then having the power. And it must be understood that we are talking about the court having a power to appoint. Now, it's very reminiscent, we would suggest, of what happened in Mutala's case. These cases are reviewed very recently by Justice Wallace in the Supreme Court of Appeal judgment in the case very aptly named for present purposes of Knoop and another, which is Klopper versus Gupta, 2021-3 South African Reports Act 135 SCA, where the whole question was the powers of a high court. That was in the face of Section 18 of the Superior Courts Act, where a full bench of the Pretoria High Court felt that it was incumbent in that case to make certain orders that had an effect on the operation of Section 18 of the Superior Courts Act, and most importantly did so without there actually having been an application for that before the court. And the Supreme Court of Appeal in this judgment again dealt with this very difficult issue of court orders that are wrong. Now, on the one hand, we know there's the Tasima category of case, where a court gives an order when it has the power to do so, but at a later stage, it appears that that power was wrong. On the face of it, it is an enforceable order, and then the question of whether it is ex nunc or ex tunc at that later stage, that order falls flat, that rises, and that's a difficult question all by itself. But, says Wallace J.A. in Kirpin Gupta's case, there is a special type of case where if on the face of it, the judgment is wrong, you cannot be held to be in contempt if you don't comply with it. And that's what you have in Mutala's case, and that's what you have in this case. Mutala's case, for whatever reason the court did so, the court made an appointment of not trustees, but of judicial managers,
of liquidators, and that power was actually with the master, and that is why the court
and the court had no power to do so. And it was within that context that the court said, well, on the face of it, you can't do that. The court cannot appoint, and we say that's exactly what we have here. On the face of it, unless there is an application, unless there is a finding, as we have it, that an appointment that an appointment has been set aside, because it must be understood that Section 131 makes provision for the setting aside of the resolution in toto, of course, and then setting aside as a different category the appointment of a BRP on certain grounds. And then in sub 6, we find that the power, the jurisdiction of the court is limited. It says that if after considering an application in terms of subsection 1b, let's grant for purposes of the argument that that happened. It then goes on, the court makes an order setting aside the appointment of a practitioner. Now, if there was no practitioner whose appointment could be set aside, it stops there. And you then do not go into the two subs of subsection 6, namely A and B, because the power to appoint arises only once the court has actually set aside the previous appointments. So, but for the setting aside, the power of appointment does not arise. And that's the way that we understand it. And now, my client said in the founding affidavit in the High Court, well, we've got quarrels about this. And as we now know from the application for leave to appeal and the answering affidavit and application for leave to appeal, in fact, there were objections. There was objection from some of the intervening parties to this whole process. And there are actually unfinished High Court cases dealing with that aspect. My client says, look, doesn't matter, that happened. And as long as that was so, that was good. They also, although there is an issue about a delegation of a power, assuming that the High Court had the power to appoint here, did the High Court have the power then to delegate the power of appointment to the Commission? We would suggest no, nowhere is that power found. But our colleagues, I apologize, our clients accept that these things happened and they lived with it. And that's why, for us, the focus falls purely and squarely on the resignation of Mr. Murray. What now? Now we sit with a junior business rescue practitioner who, on our reading of the Act, cannot even bind the company in these proceedings. So that is where we say the problems of a novus actus interveniens on the facts of this case become insurmountable for our colleagues. They might have an argument, and in the abstract, one can postulate cases where the argument works, but in this case, there was no novus actus interveniens properly proven on the facts. And that's
Thank you, Mr. Law. Thank you.
Sorry, Mr. Lowe, can I just ask then, what are we to do with the Ranchod order? Points have been raised with your colleague about things that are first raised on appeal. Now, this case was contested in the High Court on the basis that the Ranchod order was made and had to be adhered to. That was your client's allegation in the founding affidavit.
Indeed.
Is it your argument now that the order can be treated as a nullity?
For purposes of determining whether there had been, as we call it, a genetic grafting, a change of the nature of the business rescue proceedings, we would suggest in that context, yes. But
well, I prefer to avoid metaphors. Is it to be treated as a nullity, as having not been made at all?
Yes, indeed. It did not change.
If one followed that to its logical conclusion, it means there should never have been proceedings before the High Court because Mr. Moniela was never validly appointed.
Oh, yes. But you will see the supreme irony is that Mr. Moniela is now one of the applicants, and my clients don't take a point that Mr. Moniela is not properly appointed. In fact, the order that they sought was for a declaration that they, together with Mr. Moniela, was properly appointed.
Yes, now that just seems to me to flow from the stance they took in the High Court, which was that the order is there, it is a fact, and it must be accepted because it hasn't been set aside.
Justice, if I can say this, if I had acted for the company, if my client was actually the company, which is the applicant, of course, in the first applicant.
Yes, well,
for the board of the company, it would have been different for me, and I could have made a substantially different argument. But I'm acting for those who were appointed by the company, and they accept that Mr. Moniela is duly appointed BRP, and they don't bring an application for him to be struck off.
Would it be fair to say that if the order stands until set aside, then wrongly or rightly, the judge must have seen himself as making an order pursuant to Section 130. That was the application which had been brought. And nobody suggests that there's a judicial power to make an appointment of business rescue practitioners outside of Section 130, subsection 6. So he must have conceived himself as exercising that power, even if the jurisdiction to do so was in fact lacking.
Yes. No, bona fide, there's no issue with bona fides.
No, I'm not suggesting you're attacking the judges, but in fact, any of the parties' bona fides at that stage. But so given the basis on which the case was presented in the High Court, isn't it right for us to accept that de facto this was treated as an order made in terms of Section 130, sub 6? Otherwise, we don't know how to conduct any part of the case. We're completely up in the air as to Murray, to Moniela, to everyone.
But then our argument then is then you cannot accept our colleagues' invitation to deal with what happened there as a novus actus.
Well, are you saying one must treat it simply, treating Ranchod's order as an order made under Section 130, subsection 6? It nevertheless doesn't detract from the fact that when that court-appointed practitioner resigns, Section 139.3 takes you back to the company to make the appointment.
Yes, exactly.
That seems to me the legal point that the SCA was addressing. And when in its judgment it says, just find the paragraph, I marked it up, at page 155 in volume 2, paragraph 19. The judge is effectively now considering the new argument, which my colleague Justice Majid referred to, and he concludes halfway through paragraph 19, it is a fresh appointment by a company in terms of section 139.3, subject to objection again. Therefore, quite apart from the factual obstacles in its way, the respondent's new argument in this court is untenable. And the factual obstacles are noted in footnote 10. As I've indicated, the order of Ranchod J did not in terms remove Klopper and Knoop, and there's no evidence that the IDC complied with the requirements of section 130 sub 6A in respect of voting interests. I'm assuming the Judge van der Merwe is there saying that there is not evidence that the IDC on its own constituted the majority independent voting interest. Yes.
Indeed. So the
before you respond, Mr. Lowe, the 45 minutes is up, but because in the end I gave Mr. Simon 1 hour 27 minutes, you can go on. I hope that questions by my colleagues will fall within that that time frame. Thank you.
I can merely point out that unless there are further questions to me, I shall follow Justice Rogers's example and cede my time to the applicant.
Oh, I thought so. There's no response to the last point raised by my brother, Justice Rogers.
I think
I don't think it perhaps called for a response. I was just suggesting to you that the High Court seems to have taken the Ranchod order as if it were a section 136 without going into what might have been the factual obstacles.
Yes, I merely wanted to commend Justice Rogers on a good summary. That's all. But I fully agree with that submission. My point.
Thank you. Justice Rogers, are you still continuing? Are you done with your questions?
No, I'm done. Thank you.
Thank you. Thank you. Colleagues, any
Justice
questions?
Mhlanga, if I may.
Yes, please.
Mr. Lowe, I have two questions for you, please. The first relates to the equality argument that is being raised in this court. What is your response to that? Well, what is your response to the argument?
We don't agree with the argument, Justice Tron. We just do not, with the greatest of respect, see that constitutional issue of Section 9 of the Constitution into the picture. We hear what our colleague says, and we find it very interesting to listen to the argument, but we submit that it's wrong in literally all respects. There is no inequality that is created. In fact, what our colleague wants to carve out for a creditor, an independent creditor, is not equality, but precisely inequality, because he wants to locate the balance and the weight in the lap of the independent creditor at the cost of the two other corners of the triangle, namely that of the employees and of course the trade unions falling into that camp, and that of the company, the shareholders itself.
And is it appropriate for them to raise this argument for the first time in this court?
I would suggest not, but I would not, with the greatest of respect, want to become involved in an argument insofar as that's concerned. It's like urgency in the High Court. It is peace that our colleagues have to make with this court to establish that specific ground for leave to appeal, that there is this substantial issue of public importance that has to be dealt with. We just don't see it. We believe that the sections are very well calibrated, they fit in together very well, and there is no need to upset the clear wording of the sections by having resort to a concept such as equality or inequality. In fact, there are three entities that have to be taken into account, and so we we would submit that they should not be on this point entertained as a ground for granting leave to appeal.
Can I take you to section 130? That's my final question, Mr. Lowe.
Justice Strong, yes.
Subsection 1.
Yes.
It says, subject to subsection 2, at any time after the adoption of a resolution in terms of section 129, until the adoption of a business rescue plan, an affected person may apply to court. Do we know whether or not the business rescue plan was adopted?
Justice Ron, in fact, I looked this morning when I was doing my final preparation. I couldn't find any reference to it, and I understand that no business rescue plan had been adopted. If one simply looks at the time periods, the board resolution was taken on the 20th of February 2018, and the IDC removal application followed swiftly on the 23rd of March 2018. The probabilities that that Messrs. Knoop and Klopper would have had the opportunity to investigate the affairs of the company and to formulate a business rescue plan and to convene a meeting in terms of section 150 are extremely slim. And I would concede, if it needs to be conceded, that there was no meeting held, because that is the time limit is adoption of the resolution until the adoption of a business rescue plan. I don't believe that had happened. Once a plan had been adopted, that is when section 139, we understand, gets triggered. Because if you then want to remove a business rescue practitioner, you have to do so in terms of section 139.3. Apologize, not 139.3, 139.1, where it is a removal either in terms of section 130, which is up to the adoption of a business rescue plan, and beyond that, it is section 139.
Is there anything on the papers to answer whether or not a business rescue plan had been adopted?
No, it might have been perspicacious of me to have a look this morning. I couldn't find something. Maybe I overlooked it, but I'm perfectly content to concede that there had not been an adoption of a business rescue plan.
Thank you, Mr. Lowe. Thank you, Justice Madlanga.
Mr. Lowe, if I may. Jurisdiction. What's your attitude to jurisdiction?
Justice Play, if I may ask, could you please qualify explain what you mean?
You responded very politely to questions about the equality claims or inequality claims, and I wondered whether you were challenging the question of whether this court has jurisdiction to hear this application, or whether your resistance is purely on the basis that leave to appeal should not be granted.
That is our approach. We do not believe, in the first place, that this raises a constitutional issue. And secondly, we do not believe that this raises a question of such significance that this court should extend its jurisdiction. It's elective jurisdiction, of course, but in this specific case, we would suggest that this is not the type of case that should burden this court. It would settle that precedent.
Thank you. Mr. Lowe, it looks like that's the end. Thank you very much. Mr.
Thank you, Justice.
Mr. Simon?
Sorry, Judge, I am here. Just there seems to be a problem with the video. Can you see me now? Thank you, Judge. Just quite briefly in reply, you indicated I had, I think, about 10 minutes. Let me try and cover the points that I would like to in that time that was allocated to me. So firstly, Justice, just a question of nomenclature. This terminology about genetic manipulation is not an appropriate one. We're saying there's no manipulation that involved here. There was a change, a qualitative change that happened in the business rescue, where there had been a movement from the focus on the initiating appointer of the business rescue, being the company in a voluntary business rescue, to the need for the court to intervene. And once the court intervened, the court was going to make an appointment based on the recommendation of the independent voting majority creditor. And in that sense, there's no manipulation. There's a natural, qualitative, and significant change that has happened. And that change brings this process closer to Section 131 than it does to Section 129. And the reason that I say that is, if one has a look, my colleague correctly drew attention to Section 131, which is the section dealing with compulsory business rescue, and particularly Section 131 sub 5, where he referred to the fact that if the court makes an order, the court may further order an interim practitioner, the appointment of an interim practitioner who has been nominated by the affected person, subject to ratification by the holders of a majority of the independent creditors' voting interest at the first meeting of creditors as contemplated by Section 147. What I want to draw attention to is the role of the majority independent voting interests at that point, because clearly this application could be at the instance of any affected person. It may be a very minor creditor. It may be a host of different parties with different interests. But the ones who you are really interested in, once the court takes over the process, it's out of the hands of the company which had its opportunity to voluntarily go into business rescue and decided not to. The court is now in charge, and the court is deciding that the affected person, who could be a host of insignificant players, and not only one, which is I'll come back to in a moment, but if those people bring this application, what you're really interested in is to satisfy the majority of the independent voting creditors' interests. Now, if we go then to Section 130, in 130, when a business rescue practitioner requires replacement under Section 130 sub 6. Here you find the parallel again, that the alternate practitioner who is appointed in this instance, and this is in a voluntary, where there's dissatisfaction by the affected persons with the company-appointed practitioner, the appointment will be someone recommended by, acceptable to, and here's that same phrase as in Section 131, which is the holders of a majority of independent voting interests who were represented in the hearing. So what the court needs to do at this point is take into account a host of interests, and the process has undergone a qualitative change from the focal point of the initiating company appointment to one which is court managed in the interests of creditors. Now, when
Mr. Simon, can I just, your reference to subsection 5 of Section 131 raises an interesting question, because as you say, it talks about the applicant credit party affected person would have nominated somebody, but that person the practitioner is subject to ratification by the majority of the independent creditors' voting interests. If such a practitioner resigns after he's been approved, is it not significant that Section 139.3 doesn't then say that his replacement is to be the subject of the independent majority creditor's interest? The power of appointment reverts to the single creditor who applied for business rescue.
The difficulty, as we know there, Justice Rogers, is that word creditor, upon which your interpretation or some views that we're interchanging about what that might mean. Is it singular? Is it plural? Who is it? Does it require ratification or not? That word itself is misplaced. Well,
I'm not raising that point. Are you then saying that section 139.3, in the context of a compulsory business rescue, and the practitioner resigns, do you say the phrase creditor who nominated the practitioner in subsection 3 of section 139 actually means the majority of independent creditors rather than the creditor who applied and nominated?
Well, in this instance, that's the problem that Hennersberg identifies, because you might have a single limited creditor in a very small amount, or some other affected party who brings the application. But in the end, what Hennersberg is suggesting is that the word creditor in 139.3 is misplaced, because are you then talking about the creditors who ultimately under 130 sub 6 are to make the appointment, or are you talking, or the nomination or recommendation, or are you talking about the affected person now? Because under section 130 sub 6, if you read that to be whoever makes the recommendation, it must be acceptable to the holder of the majority of independent creditors' voting interest. So when so there's already a problem in formulation in terms of 139 sub 3, because what is being spoken of there? Are we talking about creditor in that sense? Is it something broader? If you look at creditor in 139.3 as being the person who, if it goes to 131, is it just the person who brought the application and now is there to be no reference to the majority? Or is it that you still require the majority, because that creditor's nomination couldn't take effect under section 131 without that? And so the use of the word creditor here is already ambiguous. So what I'm respectfully submitting to you is to base the singular, to place significance on the word singular here is not appropriate. Let's assume that creditor there means the nominating creditor who happens to be more than one affected party, actually. Say 2 affected parties bring it. It has to then cover the plural as well, because it couldn't be the nomination of just one. What I'm suggesting to you by these submissions is that not too much significance ought to be attributed to the use of the word in the singular here. The concept that underlies this is that you're really looking to satisfy the creditors, not the will of the company. And if that were not so, you could find the potentially anomalous situation that you find here. And I'm not suggesting that these are the facts here, but let's assume this to be the case, that as soon as the creditors or affected party is dissatisfied and brings an application under section 130, the practitioners resign, the company then somehow resuscitates itself to make a new appointment. It's avoided the challenge to its appointed business rescue practitioners. And then what will happen is it will just make another, and the circle will continue potentially indefinitely. The idea, the central proposition, undoubtedly in my submission as to the scheme of the Act here, is the qualitative change has happened, and you're not looking to the company to make the decision going forward as to the identity of the parties. There is no suggestion whatsoever in any application of section 130 that the company somehow has some say or its interests need to be taken into account in the new appointment. The reason is it's functus officio. When it initially made that appointment, it did so because it was the only party that could, because its decision to make the voluntary supervision operative had to be accompanied by its appointment of a business rescue practitioner, because there's no one else. There are no creditors that it could take into account when it decided on that appointment, because with the supervision had to come management, and that comes in the form of supervision.
Mr. Simon, the 10 minutes, yes. I'm giving you 5 minutes more, only 5 minutes more. Please wrap up.
Thank you, Judge. So I just want to make this point. Just on the High Court application, I mean, the one thing we do know about the IDC in the High Court application, is they submitted an affidavit in support of Monsieur's in respect of Mr. Murray, and that led to the Ranchod order. I just want to make this point that we're accused of kind of raising the Ranchod order and making something in this court for the first time. Actually, our argument is just that upon a proper interpretation, the sea change occurred with the Ranchod order. The Ranchod order is common cause, always has been. There's nothing new in it and what to do with it. The running on what happened with regard to the Ranchod order, and it was a settlement, and whether it was a surrender, whether it was something less, whether it was a tactical retreat, who participated, it all comes in the answering affidavit. It's not part of our case. In order to resist the contention that the sea change has occurred, and you have to look to the creditors now to make that determination, and not the company, they are the ones who challenge the Ranchod order and do it now. They are the ones who challenge it now. So, and all of that relates to an issue which is not before you, which is the validity of the High Court, the validity of the appointment at the instance of the company, which is the direct subject matter of the appeal. And my submission to you is that it's an interpretive exercise, and you shouldn't peer too narrowly at subsection 3 about singular or plural, but look to the purpose, as the cases that we've cited indicated that you respectfully should, and that there is a nonsensical reversion by way of regression to an institution which is functus officio in relation to its role to appointment, to resuscitate it without purpose, to allow it to make the fundamental determination which should rest with the creditors. So my submission to you is that respectfully, that there are grounds of appeal, that leaving aside the constitutional, with regard to the leave to appeal, the constitutional issue is based on section 9, which you'll either accept or not. But in any event, this is an arguable case, a matter of public interest, and it certainly is one which ought to attract your attention. And respectfully, there are no decisions on this. This is a problem which should be resolved by the Constitutional Court, and it's not necessary in order to do that to make a determination as to the effect of the Ranchod order. Mr. Lowe says there's pending process that can sort itself out. But the issue for the moment is the company appointment is invalid. There's nothing new in that, and my submission is you should find in favor of the applicants in that regard.
Thank you, Mr. Simon. Thanks to both counsel. Judgment is reserved.
May I please, Adrian?
Today's proceedings have concluded. The host will now terminate the meeting.